Hi, good afternoon. This is Judge Elisa Bettis presiding over the 210th District Court criminal docket for April 25th, 2023. All matters being heard today are being heard in accordance with all emergency orders and directives regarding COVID-19. In addition to that, we are streaming all matters live via YouTube for public viewing. Wonderful. What's our next case?
Top of page 27, Judge. In cause number 2022-0D01456, State of Texas versus Leandra Martha Daniels. Announcement of counsel, please.
Nancy Gussis for the state. State is ready to proceed.
Rick Huffman on behalf of Ms. Daniels. Judge, I believe we're ready to proceed. I don't know if they've brought out Ms. Daniels.
I received word, so you know, Mr. Huffman, from the jail that they're having some difficulty with Miss Daniels. I did have us down for a final hearing plea deadline and had signed off on plea paperwork, but I don't believe they were able to bring her over. Is that right, Mr. Marufo?
Correct, Judge. She refuses to leave her cell.
So I'm going to
Yes,
reset
Your
her.
Honor.
Yes,
Yeah, she was being combative and she didn't want to put her clothes on.
Okay, so Mr. Huffman, you know, obviously there's some concerns here. I don't know if offhand, I mean, the name resonates a little bit with me, but not really in terms of any mental health history. So I need you to make an effort to get in touch with her and see what's going on, because I did have plea paperwork already signed. I guess she was going to do just credit for time served, right?
Correct.
You know, is she receiving any treatment, mental health treatment in the jail? Do you know?
She doesn't have any diagnosis, Judge.
Mhm.
I've gone and seen her a few times where she has refused to come out. I don't know why, and I don't know what's going on there, but when she eventually does come out. And
Let me ask you this, would it be helpful to try and do this in person, or do you think it would not be worse?
Judge, it just depends on the day. I mean, she came out for a Zoom hearing a couple weeks ago in County Court 7, just fine. And when the court brought her in a few weeks ago in the 210th, she was fine. It's I don't know how to explain it, Judge. One day she does fine, the next day she doesn't want to come out of her cell. But you know, while we've been in court, she has not acted inappropriately.
Right.
Haven't had any problems communicating. She's got a factual and rational understanding of the facts and the law and the case and the roles of each party. She asks good questions. It's just sometimes she doesn't want to come out of the cell and she doesn't get along too well with the DOs.
Okay, so why don't we try bringing her in on Thursday? I think I do remember she was here one time before, so let's try bringing her in on Thursday if you're available, Ms. Casas. We'll do that as an in-person final hearing plea deadline, anticipating a plea.
Yes, Your Honor.
Okay, thank you so much.
What time will that be?
11 a.m.
Sounds good.
Okay, thank you.
Thank you, Judge.
Thank you, Judge.
Ms. Casas, is that all you have?
That's all I have, Judge. Thank
Okay.
you.
Who's next, Mr. Manufo?
Middle of page 28, Judge.
Mhm.
In cause number 2023-0D01534, State of Texas versus Brandon Ramirez. Announcement of counsel, please.
Eliana Elizalde for the state. State is ready.
Judge, good afternoon. Jesus Olias on behalf of Mr. Ramirez. We're ready as well.
Is Mr. Ramirez at the downtown jail? Is that who it
Correct.
is?
Yes, Judge.
Okay, so Mr. Ramirez is appearing remotely from the downtown jail. We are set for a bond hearing today. Mr. Olivas, you may proceed.
Thank you, Judge. Judge, I have a client who is 25 years of age, lifelong resident of El Paso, Texas. He is single. Unfortunately, the family that I've been in contact with, and as well as my client, do not have any money to make bond. He does have a lengthy record, and I think it's all associated to some undiagnosed mental issues that for some reason nobody's been able to catch it. But nonetheless, he is unemployed, and that's a difficult time holding down jobs. Consequently, Judge, the only thing we can ask for this time to get any sense of him getting out is some sort of PR bond.
All right, Ms. Elizalde?
Judge, we would oppose any bond reduction or modification. The facts are very concerning. Officers were dispatched in reference to a subject disturbance call. They arrived and they saw the defendant, who was matching the description on the call, asked what he was doing there, and he stated he was looking for his wife. Defendant was stumbling, stated he had a couple of alcoholic beverages. Defendant stated he found his wife's fiance address on the white pages. And when asked why he would need to look her up, he just said he needed to find her. A friend dropped him off in the area. The victim is a detention officer. It is advised that a male was calling, stating that she was his wife. The detention officer said that she'd never met him before. She found his social media saying, "Where's Brittany?" which is the name of the complainant, and "My wife is a cop." As to criminal history, we have theft 1244B, 100 days in 2017, theft misdemeanor in 2016, a theft state jail felony in 2017, a theft enhanced to TDC, and one of the thefts he was revoked in, that was on one in 2017, a robbery 2022 dismissed, and resisting and evading dismissed. Judge, I think we have history of revocation here. I don't think he will listen to his bond conditions. I don't think he'll be able to follow them. The facts are extremely concerning. And so the state at this point would oppose modification of bond.
Anything else, Mr. Rivas?
No, Madam Judge.
Okay, looking at the nature and circumstances, I guess of this offense, the prior criminal history to include some non-compliance with bond conditions, the request to reduce the bond is denied. Mr. Olivas, if there is a mental health concern here, I don't know if he's receiving any treatment in jail, but if you need to come back and seek some relief, if you have more information, maybe EHN can screen him and we can, or you can present a plan that you want me to consider that we don't have today. I'm happy to reset it. We're set for arraignment. We were set for arraignment last week, and I do see we have that paperwork still outstanding. So please get the waiver of arraignment in. Thank you very much.
Thank you, Judge.
Take care.
I have another one, Judge. I don't know if you want to entertain me now at this point with
Sure.
Kayla.
Let me just, Miss Mendiola, is that all we have downtown?
Yes, ma'am.
Thank you very much.
Have a good day.
Okay, who's, yeah, we can do Kayla Mendiola next.
Yes, ma'am. The schedule is a probation status issue.
Annex, is that Ms. Mendiola?
Looks like.
Yes, sir.
In cause number 2020-0D06119 and 2021-0D00743, State of Texas versus Kayla Mendiola. Announcement of council, please.
Eliana Elizalde for the state. State is ready.
This was Leos on behalf of Ms. Mendiola. I'm ready as well, Your Honor.
And Ms. Mendiola is appearing from the jail annex. Both cases are set for probation status hearing. She had absconded. Let's see. Let me go back. Back in January. She failed to turn herself in back in November. Let me keep going back. Do we have all of her cases? So when she pled, was that all of her cases, or do we have anything else outstanding?
I see another one, Judge. It's a 2020-0D06116.
That's strange.
Your Honor, I believe
Mhm.
that's also a probation case.
I'm sorry?
I believe that's also a probation case, the 6119 at the end.
6119, but were you saying 6116? Or was there another one, Mr. Olivas?
The one I have is 6116. Yes, ma'am.
Oh, I apologize.
The one on the docket ends 6119, assault peace officer judge, and then an aggravated assault. So it looks like through the end of 2022, we were having a lot of issues with Miss Mendiola. Was there a mental health concern, Carla? I remember the name and I can just see her and I kind of remember that, but I don't want to misremember other things. Was she receiving any mental health treatment? Was there a need?
Judge, I'm sorry to interrupt, but I received a 1622 that does indicate there was issues,
Got it.
bipolar and depression.
Were we handling those on probation, Carla?
Your Honor, she was supposed to be attending. However, that's when she was released from custody. And she failed to report effective November 2022. She
Mhm.
was supposed to do a jail commitment, and then she was probation officer had secured some appointments for her, but she didn't report anymore.
Right, and then she had an old case and then a new possession of marijuana in 2022. We admonished her, we give her the 10 days. Well, Mr. Olivas, does she want to just do her time?
That's something I need to go and discuss with our judge, but my concern is her mental status. I don't know if she's gonna be getting the proper care and service that she needs while incarcerated.
Mhm. Recommendation for probation is to extend her the number of months that she absconded and continue services with the EHN, but that's just, to me, no, that's not gonna work. So we need to get a better handle on her. What I'm gonna do is reset the probation status hearing for an update. We don't have to do it at the jail slot. We can do it at the regular slot to see if we have some more information on her treatment. But if you want it at the jail slot, Mr. Olivas, we can do that as well. And then 2 weeks from that, I want a pre-revo. And 2 weeks after that, a contested revo or plea of true.
Yes, ma'am.
Okey doke. Thank you.
Thank you, Judge. May I be excused?
You may. Who's
Thank you.
next?
Bottom of page 28, Judge.
Mhm.
Annex, may we have Eileen Reese?
Well,
Is that Miss Reese?
Yes, ma'am. Yes, Your Honor.
Okay, perfect. Let's go.
Clause number 2022-0D04904 and 2022-0D01523, State of Texas versus Eileen Reese. Announcement of council, please.
Eliana Elizalde for the state. State is ready.
Rick Huffman and Robert Harris on behalf of Ms. Ruiz.
And Miss Reese is appearing remotely from the jail annex. We are scheduled in each of these cases, Miss Reese, for pleas. We are conducting these remotely, in other words, over Zoom, but of course, you had the right to do it in person. I did receive a waiver of that right that appears to be signed by you and your attorneys. Mr. Marufo, will you double check that I have both waivers from each attorney?
Yes, Judge.
But as we looked that up, Ms. Reese, is that in fact your desire to do this over Zoom?
Yes, Your Honor.
Okay. So I'll go ahead and get started with your plea. To do that, I need to swear you in. Would you raise your right hand, please? Do you swear or affirm that any testimony you provide will be the truth and the whole truth?
Yes, Your Honor.
Ms. Reese, you can put your hand down. Thank you very much, and state your name and date of birth for the record.
Eileen Reese, 0426 of 89.
Ms. Reese, as to both of these cases, your pleas are documents, the first of which in each case are marked as State's Exhibit Number 1. Those are the plea papers in each of these cases. Within those documents, you're guaranteed certain rights, including the right to remain silent, the right to trial by jury, the right to counsel, the right to confront and cross-examine witnesses, and the right to call witnesses on your behalf and in your defense. Ms. Reese, do you recall reviewing each of those documents with your respective attorneys and signing those documents?
Yes, Your Honor.
Did you understand everything contained within the documents?
Yes, Your Honor.
Mr. Harris, have you had more than 10 days to prepare a defense in this case?
Yeah.
And Mr. Huffman, have you also had 10 days to prepare in your case?
Yes, Your Honor.
Did each of you explain the plea papers to your client?
I did. Yes, I did, Your Honor.
And do you each believe that she has understood the admonishments, rights, and consequences of giving up these rights by entering her pleas today?
Absolutely, yes. Yes, Your Honor.
Ms. Reese, are you satisfied with each of your attorney's representation of you?
Yes, Your Honor. Very satisfied.
Mr. Harris, any reason to believe your client is not presently competent to enter her plea?
No, Your Honor.
Mr. Huffman, any reason to believe she's not competent?
No, Your Honor.
Ms. Reese, have you ever been found mentally incompetent by any court?
No, Your Honor.
Ever been examined by a doctor or psychiatrist who has found you mentally ill?
No, Your Honor.
Based on your testimony, your attorney's representations, and my observations of you, I'm going to find that you are competent to enter your pleas today. Ma'am, are you a U.S. citizen?
Yes, Your Honor, I am.
Where were you born?
I was born in El Paso, Texas at Providence.
So in cause number ending 4904, you were charged by indictment with 2 state jail felonies. Count 1 is a theft of property in an amount between $2,500 and $30,000. That charge, ma'am, what is your plea? Guilty or not guilty?
Guilty, Your Honor.
In count 2, unauthorized use of a vehicle. To that charge, guilty or not guilty?
Guilty, Your Honor.
In cause number ending 1523, the charge is possession of a controlled substance in penalty group 1 in an amount between 4 and 200 grams. To that charge, ma'am, what is your plea? Guilty or not guilty?
Guilty, Your Honor.
Are you making each of your pleas freely and voluntarily?
Yes, Your Honor.
We'll find you are making your pleas freely and voluntarily. Ms. Elizalde, would you summarize the evidence, please?
Yes, Your Honor, as to cause number ending in 4904, had the state proceeded to trial, the state would have been able to prove that on or about the 3rd day of April 2022, and interior to the presentment of this indictment in the county of El Paso and state of Texas, Eileen Moriah Ruiz, hereinafter referred to as defendant, did then and there unlawfully appropriate by acquiring and otherwise exercising control over property other than real property, to wit, Jeep motor vehicle of the value of $2,500 or more, but less than $30,000, without the effective consent of the owner, namely Ross Road Service or Manuel Cardosa, with intent to deprive said owner of said property. As to count 2, did then and there intentionally knowingly operate a motor propelled vehicle, to wit, a Jeep automobile, without the effective consent of Ross Road Service or Manuel Cardosa, the owner thereof. And as to count 1520, ending in 1523, had the state proceeded to trial, the state would have been able to prove that on or about the 18th day of April 2021 and interior to the presentment of this indictment in the county of El Paso and state of Texas, Eileen Moriah Ruiz, hereinafter referred to as defendant, did then and there intentionally or knowingly possess a controlled substance, namely methamphetamine, in the amount of 4 grams or more, but less than 200 grams. Your Honor, as to each cause, I have submitted State's Exhibit 1, the plea papers, and State's Exhibit 2, the disclosure form, and I would ask that they be introduced into the record.
Any objection on cause number, oops, lost it. Cause number ending 4904, Mr. Harris.
No objection.
States 1 and 2 are admitted there. As to cause number 1523, Mr. Huffman. You're muted.
No objection.
States 1 and 2 are admitted there. What is the plea agreement?
The plea agreement calls for 10 years confinement, probated for 5 years with community supervision throughout the period of probation. The defendant is to be assessed a fine of $2,000, 250 hours of community service, TAP, UABA, curfew, and standard terms and conditions.
So in this case, I understand that 10 for 5 as to cause number ending 1523, but plea papers on 4904 reflected 2 for 5 on the state jails.
That is correct, Your Honor.
Okay, Mr. Harris, is that your understanding of the plea agreement?
It is.
Mr. Huffman?
Yes, Your Honor.
And Ms. Reese, is that your understanding of the plea agreement?
Yes, Your Honor.
I understand that the plea agreement is not binding on the court. However, if I were to reject it, I would allow you to withdraw your pleas. If I follow the plea agreement, you may not appeal these cases except on matters raised by written motion and ruled on before trial or by permission of the court. The next document I'm going to ask you about is the 1-page document entitled The Trial Court Certification of Your Right to Appeal, 1 for each case. It is a document that explains your appeal rights. Because these are plea bargained or negotiated cases, you do not have an automatic right of appeal. Ms. Reese, do you recall reviewing the trial court certification with your attorneys and signing those documents?
Yes, Your Honor, I do.
They were signed by your attorneys and signed by the court as well. So on your pleas of guilty and the evidence introduced, I will accept your pleas and at this time find the evidence substantiates your guilt. In cause number 2022-0D04904, I will find you guilty of the offenses of theft of property, $2,500 to $30,000, and unauthorized use of a vehicle, and I will sentence you there to the plea agreement to 2 years confinement in the Texas Department of Criminal Justice State Jail Facility that will be suspended for a period of 5 years of community supervision. In cause number 2022-0D01523, I will find you guilty there of possession of controlled substance in penalty group 1 in an amount between 4 and 200 grams, and will sentence you to 10 years confinement in the Texas Department of Criminal Justice Institutional Division and suspend that for a period of 5 years of community supervision. In each of these cases, the fine is $2,000. I got to think that she is continuing to be indigent, and so I'm going to probate the entirety of the fine, which means that Ms. Reese, you will not owe the fine unless you are not in compliance with your probation, and then they can come back and collect the entire fine. 250 hours, double check. 250 hours of community service, TAP screening, urine and breath analysis, curfew, and you are to have no contact with the location in cause number 4904. These sentences will run concurrent with one another. Is there anything further, Ms. Elizalde?
No, Your Honor.
Mr. Harris?
Nothing further, Your Honor.
Mr. Huffman?
No, Your Honor.
Ms. Reese, good luck to you, ma'am.
Thank you, Your Honor.
Thank you very much. Who's next?
May we be excused?
You may. Thank you, Mr. Harris.
Then on page 27, Judge. Annex, may we have Michael Martinez?
Oh, hold a second. Hold on. Call Mr. Harris. Is he the one or is it? No, it's Mr. Huffman.
Mr. Hoffman, Judge.
Okay, so we need to let that, Mr. Huffman, you are. The waivers of arraignment need to be returned to the court before the plea. Why is this not happening? And Mr. Marufo, why am I being told this at the end of the plea?
I apologize, Judge. I did let Mr. Hoffman know prior to the hearing today.
Look for it, Mr. Huffman. We're going to reset her for Thursday. Who's next?
Staying on page 27, Judge. Annex, may we have Martinez? Michael
Yes, sir. Give me
Martinez.
1 second. Martinez.
While we're waiting, Ms. Welch, I think
Yes, Judge.
we not too long ago had a list. Can you run me a new list of 2022 cases that are open where we do not have waivers of arraignment, please?
Okay, I will do that.
Thank you.
Thank you.
Okay, who is this?
Michael Martinez, Judge, on page 27.
I'm here, Your Honor. Good afternoon.
All right, go ahead.
In cause number 2021-0D0-1222 and 2023-0D0-1664, State of Texas versus Michael Allen Martinez. Announcement of counsel, please.
Juliana Elizalde for the state is ready.
Oh, the codes for Michael Martinez. We are ready. Good afternoon, Judge. I hope we have our waivers in.
Good afternoon, Your Honor. Brisa Martinez, adult probation.
So these are both probation cases, right? Oh, no, I'm sorry. We have a 2023.
One's a new one. Yeah.
We're set for bond hearing. Go ahead,
Yes,
Mr.
ma'am.
DeCruz.
Thank you, Judge. So my client is a nurse or was a nurse. Initially in your court, the same offense we got, I believe it was 5 years deferred. We're trying to save his career. Unfortunately, it's alleged that Mr. Martinez is continuing to make money in a way he should not make
Mr.
money.
DeCotes, I'm having a lot of trouble hearing you. There's, I don't
I'm
know.
sorry,
if
Your
there's background noise.
Yeah, give me 2 seconds. Sorry about that, Your Honor. I was meeting with another client and it was loud. Anyway, so he picked up the same charge, Judge, and it's a bummer. The only thing I have is that it's a non-violent charge, but he's alleged to have been trying to sell meth again.
Didn't he just speed? I feel like I've
Yes.
seen him.
Yes,
like, not-
Your Honor. Yes, I know.
All right, what
I know.
are his
So
bonds?
here's what I'm asking. Real quick, Your Honor. He kind of knows that he's looking at time unless I can find a problem. And what he wants to do is be a trustee. And his bond right now is at $50,000. or above that, and they won't let him be a trustee. He's hoping for a reduction to like 40. He's not going to be able to get out.
So he's at 70,000,
Yeah.
on the 2023 case, and then no bond on the probation case. And he's on deferred, is that right?
Yes, Your Honor.
Do we have a motion filed on the 2021 case, Ms. Elizalde?
We do, Your Honor.
Okay. All right. So let me hear you on the bond.
Judge, well, I would oppose any bond modification just because he just got on probation, as was mentioned earlier. There was a traffic stop. The defendant opened the door, stepped out. They told him if he steps out, they would have to check him for weapons. He disclosed he had 2 knives on him. The officers observed a baggie with a clear crystal-like substance. And it was located in the passenger backseat. They found another bag that contained 219.5 grams of what tested positive for meth, a field test, and fentanyl 35 grams. It's an unassigned felony, which I know carries a minimum. He's definitely looking at TDC, so I have concerns, and that's the basis for opposing bond modification, as I do look to revoke him on the deferred case.
All right. So he's entitled to a bond on the deferred. Ms. Martinez, were you on this case? Did you have anything for me? I saw you turn on your camera.
Good afternoon, Your Honor.
Good afternoon.
No, Mr. Martinez never reported to me after he was released, I believe in November. I conducted a home visit. It was unsuccessful. So he hasn't reported to me for probation. He was supposed to report bi-weekly and to provide 2 monthly UAs with 24 hours notice. So he hasn't been complying with me. And I don't have any updates, and he has been non-compliant, not reporting to me.
Yeah, this is probably worst case scenario for me. So the request is denied on the 2023 case. Bond will stay at 70. In 2021, his bond is 100,000. Thank you very much, Mr. DeCote.
Thank you, Judge. Have a great day.
And your
Bye-bye.
waivers in, I saw it.
Excellent.
Right. Who's next?
Bye-bye.
Top of page 28, Judge.
Mhm.
Annex, may we have Eddie Morris?
Yes, sir. Give me 1 second. Sir.
Good afternoon, Your Honor. Good afternoon, Ms. Solis. So it looks, oh, go ahead.
In cause number 2018-0D01845, State of Texas versus Eddie Morris. Announcement of counsel, please.
Eliana Elizalde for the state is ready.
Araceli Solis on behalf of Mr. Morris, Your Honor, ready to proceed.
And Mr. Morris is appearing from the jail annex. We are scheduled today for a probation status hearing. It can tell you, and I don't know if this has changed, if probation can chime in here, Ms. Solis, but he was still pending assessment as of the 21st of April, and the referral was submitted to the jail back on April 5th. I'm not quite sure if that was just to kind of maybe convince the court not to go with TDC time, but you know, I don't know if there's an update. Carla, do you know if there's been an update there?
Your Honor, I have been trying to reach Mr. Bruce, his assigned probation officer, regarding the appointment stated on the summary, but I don't have much information, only that he was referred on 4/21, which I believe that was Friday's date. It usually takes 5 days to get seen. So as of right now, there is no update or anything else to provide to the court regarding that assessment that's pending.
Well, it says the referral was submitted to the jail on April 5th, and then a follow-up was submitted on April 21st, and we still haven't gotten that done. I'm not sure why. But What was the time rec, Ms. Elizalde?
3 TDC, Judge.
Ms. Elise, are we there on the time or what does he want to do?
No, if you recall, back when we had the hearing on March the 30th, I know you wanted an assessment done before you would consider him being released. You also wanted the appointment with EHN, so we reset this because you wanted us to have some type of exit plan. So I did reach out to Ms. Pineda, and she emailed me the same thing, Judge, that the referral was submitted to the jail on the 5th, and the follow-up was submitted on the 21st. So I know I also CC'd Ms. Elizalde regarding the email correspondence that we had. So Judge, I'm hoping, I know the recommendation last time from the probation department was to continue him on probation. So I was hoping to do that, Judge, but I know that the court had some concerns. So obviously they wanted him assessed. So I would ask that the court do that.
Right. Okay. So I'm gonna reset him for 1 week and find out. We'll have to hear from the jail, find out why we're not getting any responses on these assessments.
Okay, Judge, and I'll respond. I'll touch base again with Ms. Pineda. You said 1 week, Judge?
Yeah, we're gonna do 1 week. I mean, we have this outstanding for 3-4 weeks now. So 3 weeks, I guess. So let's find out what's going on. Reset 1 week. Thank you very much.
Thank you, Your Honor. Maybe
Who's
excuse.
next? Yes, ma'am. Thank you.
Staying on page 28, Judge. Annex, may we have Rochelle?
Yes, sir. 1 second. Yeah.
Right.
In cause number 2021-0D01401, State of Texas versus Xavier Jonah Rochelle. Announcement of counsel, please.
Eliana Elizalde for the state. State is ready.
I'm Gandara for Javier Rochelle. We're ready, Your Honor.
And Mr. Rochelle is appearing from the jail annex. We have a bond hearing and probation status. Let's go ahead and start with the bond hearing.
Your Honor, he's been detained continuously since at least October, and prior to that before, since October of last year. He had a detention. He was on federal supervised release, and that was revoked. He did 6 months. He was the misdemeanor court judge put him on issued a warrant just so she could get him back, and those 2 cases are pending. They're evading arrest and resisting arrest. And he is through doing his time with the feds, and he's done like I think if we calculate the time in this case, maybe as much as 8 months. I haven't done an exact count yet, but he's back. He's from El Paso. He has support, mainly his grandmother and his mother, and he wants to confront those cases. The misdemeanor cases might be dealt with time served. Depends on the situation. In any event, if you would PR him, and we can work these things out and come back to court and get it disposed of one way or the other.
When was he in custody, in federal custody, starting when?
Well, at least the most recent, he was revoked and sentenced in October. Judge Briones gave him 6 months.
All right, Ms. Elizalde.
Judge, I have here that I have filed a motion to revoke. I think it's telling that he got revoked on federal. I don't think he's going to do well on probation. And so that's kind of where I'm at, Judge.
Yeah. Yeah, I agree. Probation status, let's see, I see the misdemeanor 2022. But it doesn't look like his performance was very promising. And yeah, I think I'm at 2 TDC on each of these cases.
Would there be any way to re-sentence him to a state jail, Judge, and you give him a time served?
No, sir. No. No, I'm at 2 TDC, so in terms of the bond, he's on deferred. He's probably no bond on each of these cases. So I'm gonna put a $50,000 bond for each of his cases. Just straight cash surety. And I'm at 2 TDC. I'm gonna go ahead and set it for, are motions filed on him, on these cases?
The motion to revoke is filed, Your Honor.
Yeah.
And the other two are misdemeanors and those are filed, but those will go along with whatever happens in this case.
Right, I see a motion to adjudicate at least on one of them on March 29th. So let's set it for a pre-revocation hearing in 2 weeks. And 2 weeks after that, contested revo or plea of true. Get up.
So yes, Your Honor.
Thank you very much. Thank you, Mr.
Thank you.
Rochelle. Who's next?
Bottom of page 29, Judge.
Mhm.
Annex, may we have Cifuentes, Carlos Cifuentes?
Go ahead. Oh, never mind. I don't see a defendant. Go ahead.
In cause number 2022-0D01212, State of Texas versus Carlos Alberto Cifuentes. Announcement of counsel, please.
Roa King for the state of Texas. Good afternoon, Your Honor.
Good afternoon.
And Daniel Avalar for Mr. Cifuentes. Good afternoon, Your Honor.
And is that your client, Mr. Avalar, from the jail?
It
annex?
is, Your Honor. I recognize him.
Okay, so Mr. Cifuentes is appearing from the jail annex. We are scheduled today for a status conference. I see a slate of settings leading up to our February 9th, 2024 jury trial. What is the rec, Ms. King?
Your Honor, it is 35 years TDC.
Okay. How are we doing? Is everybody on track? I mean, I feel like it's kind of early on.
We are on track so far, so good, Judge. Two things, and I discussed this with Ms. King. Number one, we're gonna discuss that recommendation with Mr. Cifuentes. And number two, Judge, I hesitate to discuss that without the benefit of the fingerprint experts the court allowed us to get. We're still waiting on his report. But Judge,
I thought it was ballistics. The ballistics, or is it fingerprint?
it's also fingerprint as well. You're right. There is a ballistic expert, but we're waiting on. Can you hear me, Your Honor?
Yes, I can.
Okay, we're waiting on the report from the fingerprint expert. I think we're waiting on a palm.
Okay.
What it is. But yeah, that's kind of where we're at. The wheels are in motion. I think we're on track.
Okay. Well, then we'll see you at the 6:20 judges conference.
Okay. Yes, ma'am.
Thank you,
Thank
Judge.
you very much.
May I be-
Next. Thank you. You all may be excused.
Okay. Thanks. Bye.
Bye-bye. Who's next?
Page 19, Judge. Annex, may we have Marcus Hall?
So Mr. Hull had 3 cases, right?
Yes, Your Honor.
I'll be dismissing one, Judge.
The 1314?
The assault on a peace officer.
Okay. I'll just, throw this out there. It's helpful if you'll notate that on the plea paperwork, because then I'm asking about plea papers if I don't see the dismissal being part of the plea.
Yes, Judge, I'll adjust moving forward because Mr. Marupo had the same question for me on another one, so I'll notate it.
All right, go ahead.
In cause number 2021-0D00237 and 2019-0D02396 and 2020-0D01314, State of Texas versus Marcus Allen Hall. Announcement of counsel, please.
Eliana Elizalde for the state. State is ready.
John Williams for Marcus Hull, ready, Your Honor.
And Mr. Hull is appearing from the jail annex. Mr. Hull, I have you scheduled today for a final hearing plea deadline on each of these 3 cases. However, I did receive hand-delivered plea paperwork from your attorney, Mr. Williams, indicating to me that at least on 2 of these cases, your intention is to plead. Is that what you understand is happening today? I'm sorry, I can't hear you.
Yes, ma'am.
Okay, so I'll just need you to speak up a little bit. Sometimes just the audio is weird sometimes. So I'm going to go ahead and get started with your plea. So I need to swear you in. If you would raise your right hand, please, sir. Do you swear or affirm that any testimony you provide will be the truth and the whole truth?
Yes, ma'am.
Thank you very much. You can put your hand down. Would you state your name and date of birth for the record?
Marcus Hall, 9/1/75.
Okay, thank you. I don't know what's going on with the audio, Mr. Hall, but the louder you speak, the clearer it is, okay?
Yes, ma'am.
Mr. Hall, I also, with part of the plea paperwork, received a form, a consent to conduct this plea via video conference, in other words, Zoom. Are you in agreement with that?
Yes, ma'am.
Okay, so let's go ahead and get started with your pleas, sir. In each of these cases, you received documents, the first of which is marked as State's Exhibit number 1. Those are the plea papers. Within those documents, you're guaranteed certain rights, including the right to remain silent, the right to trial by jury, the right to counsel, the right to confront and cross-examine witnesses, and the right to call witnesses on your behalf and in your defense. Mr. Hall, do you recall reviewing those documents with your attorney and signing them?
Yes, ma'am.
Do you understand everything contained within those documents?
Yes, ma'am.
Mr. Williams, have you had more than 10 days to prepare defenses in each of these cases?
I have, Your Honor.
And did you explain the plea papers to your client?
I did, Your Honor.
Do you believe he has understood the admonishments, rights, and consequences of giving up these rights by entering his pleas today?
Yes, Your Honor.
Mr. Hall, are you satisfied with your attorney's representation of you?
Yes, ma'am. Very much so.
Mr. Williams, any reason to believe your client is not presently competent to enter his plea?
None at all, Your Honor.
Mr. Hall, have you ever been found mentally incompetent by any court?
No, ma'am.
Ever been examined by a doctor or psychiatrist who has found you mentally ill?
No, ma'am.
So based on your testimony, your attorney's representations, and my observations of you, I'm going to find that you are competent to enter your pleas today. Sir, are you a U.S. citizen?
Yes, ma'am.
Where were you born?
Vineland, New Jersey.
What was the name of that city?
Vineland, New Jersey.
So in cause number 2021-0D0-0237, you were charged with the 3rd-degree felony of failure to comply with the sex offender's duty to register lifetime. To that charge, sir, what is your plea? Guilty or not guilty?
Guilty.
In cause number 2019-0D0-2396, it's the same 3rd-degree felony offense. What is your plea? Guilty or not guilty?
Guilty, ma'am.
Are you making each of your pleas freely and voluntarily?
Yes, ma'am.
I'll find you are making your pleas freely and voluntarily. Ms. Elizalde, would you summarize the evidence, please?
Yes, Your Honor. Had this case proceeded to trial, the state would have been able to prove that on or about the 30th day of January 2019, and anterior to the presentment of this indictment in the county of El Paso and state of Texas, Marcus Allen Hall, hereinafter referred to as defendant, did then and there, while being a person required to register with a local law enforcement authority in the municipality where the defendant resided or intended to reside for more than 7 days, to wit, El Paso, because of a reportable conviction for sexual assault of a child, intentionally or knowingly failed to report in person to the local law enforcement authority in which the defendant's new residence is located, and provide the authority with proof of identity and proof of residence no later than the 7th day after changing the address or the first date the applicable local law enforcement authority by policy allow the person to report. As to cause number ending in 0237, had this case proceeded to trial, the state would have been able to prove beyond a reasonable doubt that on or about the 5th day of May 2020 and anterior to the presentment of this indictment in the county of El Paso and state of Texas, Marcus Allen Hall, hereinafter referred to as defendant, paragraph A, did then and there, while being a person required to register with the local law enforcement authority in the municipality where the defendant resided or intended to reside for more than 7 days, to wit, El Paso, because of a reportable conviction for sexual assault of child, intentionally or knowingly failed to report in person to the local law enforcement authority in which the defendant's new residence is located, and provide the authority with proof of identity and proof of residence not later than the 7th day after changing the address, or the first date the applicable local law enforcement authority by policy allow the person to report. Paragraph B, did then and there, while being a person required to register with the local law enforcement authority in the municipality where the defendant resided or intended to reside for more than 7 days, to wit, El Paso, because of a reportable conviction for sexual assault of a child, intentionally or knowingly failed to report in person to the local law enforcement authority in which the defendant's new residence is located, and provide the authority with proof of identity and proof of residence not later than the 7th day after his release from El Paso County Jail, or the first date the applicable local law enforcement authority by policy allow the person to report. Your Honor, as to each cause, the state has submitted State's Exhibit 1 plea papers and State's Exhibit 2 disclosure form. We would ask at this point that the court introduce into the record State's Exhibit 1 and 2.
No objection, Your Honor.
States 1 and 2 are admitted as to each case. What is the plea agreement?
Your Honor, the plea agreement is for 3 years confinement in the Texas Department of Criminal Justice with no period of community supervision. In addition, the state will follow up with a dismissal and cause number ending in 1314.
Mr. Williams, is that your understanding of the plea agreement?
It is just, Judge, I just want to make sure that we put in the order that they're running concurrent.
That's correct. Mr. Hull, with that addition, is that your understanding of the plea agreement?
Yes, ma'am.
Understand that the plea agreement is not binding on the court. However, if I were to reject it, I would allow you to withdraw your pleas. If I follow the plea agreement, you may not appeal these cases except on matters raised by written motion and ruled on before trial or by permission of the court. The next document I'm going to ask you about is the one-page document entitled The Trial Court Certification of Your Right to Appeal. It is a document that explains your appeal rights. Because these are plea bargained or negotiated cases, you do not have an automatic right of appeal. Mr. Hull, do you recall reviewing the trial court certification with your attorney and signing that document?
Yes, ma'am.
They were signed by your attorney and signed by the court as well. So on your pleas of guilty and the evidence introduced, I will accept your pleas and at this time find the evidence substantiates your guilt. In cause number 2021-0D00237, I will find you guilty of failure to comply with sex offender duty to register, and I will sentence you there. According to the plea agreement, 3 years confinement in the Texas Department of Criminal Justice Institutional Division. In cause number 2019-0D02396, same offense, find you guilty of failure to comply with sex offender duty to register, and sentence you also to 3 years TDC there. Both sentences will run concurrent with one another. As soon as I receive it, I will sign a dismissal on cause number 2020-0D01314, as that was part of the plea agreement as well. Is there anything further, Ms. Elizalde?
No, Your Honor.
Mr. Williams?
Judge, he was taken into custody on these cases on February 9th, along with the 2014 0D04257, but for some reason, the jail booking is not showing that he was booked on these two offenses. So I just want to make sure that he gets credit for these offenses from February 9th.
So is that correct, Miss Welch? I'm looking, I just see detainers on counts 1, 2, and 3. Let me go into that.
Yes, Judge. So I do see he was booked on February 9th. So as of today, he has 76 jail credit days.
And that's for these cases, yes?
That is for these cases, but 5/5/2020. I'm just trying to make sure that I can also add 4 days because he was booked from 10/11/2020 and it is after the date of offense.
Perfect.
Right. I see that prior jailing, but I just want to make sure that and that's fine to do that. I don't have a problem with that. I just want to make sure that as he's being held right now, he's being held on all 3 of the cases that are on today's docket.
I see what you mean. If you like, what I can do is I can email the jail coordinators. So, and ask them to perhaps maybe when I do the detainer, we can add him to be detained on this case. And if you prefer, I can give jail credit.
So what I'm going to want to do, because it's not clear to me from this jailing, I feel like it's maybe what Mr. Williams is saying. At first, when I glanced at it, Mr. Williams, I thought it was the 3 cases, but now that I'm looking at it, it's count 1, 2, and 3. And I believe those are the previous cases, the ones that came out of the 168. So that the record is clear, he should have been booked on our cases. I'm not sure why he wasn't booked on February 9th on that. So he will receive credit for all time that he was booked from October 11th, 2020 to October 14th, 2020, and beginning on February 9th, 2023 until now. I mean, that's the beginning on February 9th. Okay?
Perfect. Okay.
So, alrighty, and Ms. Welch, I'll get with you if you need something from me on that, okay?
Okay, thank you.
Thank you. Mr. Hall, good luck to you, sir.
Thank you, ma'am.
Who's next?
Thank you, Judge. Can I be excused?
Thank you very much.
Thank you.
Bottom of page 25, Judge.
Mhm.
Annex, may we have Chavez?
Coming right up.
Okay, go ahead.
In cause number 2023-0D0-0983 and 2022-0D0-2583 and 2020-0D0-6487 and 2021-0D0-0712 and 2021-0D0-2709, State of Texas versus Barnaby Chavez. Announcement of council, please.
Eliana Elizalde for the state on the probation cases and covering for Preston Munson. On the
Brett
rest.
Stevens for Mr. Chavez, and we are ready also, Your Honor.
Okay, and Mr. Chavez is appearing from the jail annex. It looks like, I guess I overlooked this. We do have a 2023 case set for arraignment today, but we have a 2022 case set for final hearing plea deadline and then our probation cases. Why doesn't somebody give me an update on Mr. Chavez? Obviously, we're early on the new cases, but had you had a chance to look at that, Mr. Stevens? I can't remember if maybe we had talked about it before, or not.
We have a plea agreement, Judge, and I sent in plea papers. We were expecting to do a plea today.
Oh, well, let me see. Do we have plea papers?
Yes, Judge. I can resend them, Judge.
Did we have all the plea papers?
Judge,
Yes.
I'm covering for Preston, but in talking to Mr. Stevens, I believe I'm dismissing a couple. So that's why you don't have plea papers for all. I am reviewing it as I go, as I'm covering.
Okay, so until we find those, we'll have to come back to this case. Is there any others that are ready?
Yes, Judge.
Okay, Mr. Chavez, so I'm going to look up your paperwork, so we'll come back to you, okay? Okay.
Annex, may we have Alvarez staying on page 25, Judge? We have Christopher Alvarez?
Wait up.
What?
Because number 2022-0D0-0792 and 2022-0D0-0253 and 2021-0D0-1337 and 2021-0D0-0772, State of Texas versus Christopher Ray Alvarez. Announcement of council, please.
Eliana Elizalde for the state is ready.
Rick Hoffman on behalf of Mr. Alvarez, we are ready.
All right, and Mr. Alvarez is appearing from the jail annex. All of these cases are set for a judge's conference. Let me see. And we have a jury trial in May. What's going on? These cases.
So Judge, the state has made a recommendation that has been rejected, and it's my understanding that we're moving forward with jury selection on May 4th.
Okay. So let me see, how many are there? 1, 2. So my thought is that we will go on 1337.
Yes, that's also what I was expecting, Judge.
Okay, But they're all set, so, I mean, you kind of have to be ready. I don't know if anything falls through. We have our final hearing plea deadline on May 2nd. On the May 5th trial, I can tell you that we'll do jury selection May 4th and 5th. Let me pull up we're in Commissioner's Court on both days. But I can tell you we may have somewhat of a delay. Myrna, is this one that we have coverage for? I can't remember if that's what we discussed this morning.
We just requested coverage, Judge.
Okay, and I bet I didn't include the 4th, right?
No, it starts on the 5th.
On the 5th, yeah, because I didn't think of 2 jury panels. We probably need to ask to see if we can have the coverage start on the 4th. Folks, so I will be out on 2 of those days for the following week, so I requested coverage. We can do a couple of things. I can handle it, but it will mean a delay in the evidence portion of trial. So that will mean that we start evidence on the 9th. Or you all can just deal with the visiting judge and do 4th until we finish, or until you finish.
Judge, my preference would have been for you to handle it, but I do have one of the witnesses who has a scheduling conflict. And I was hoping to put her on either Friday or Monday to get her on her way.
Okay. Mr. Huffman, anything?
Judge, the only thing that I'm thinking, and I don't know, I think we could probably have the visiting judge do it. I'm working on a motion to dismiss for a speedy trial violation, and the reason being is this case took 3.5 years to get for my client to get arrested, and due to that delay, there are some text messages and some messages from the that are exculpatory that we cannot retrieve. So I'd like to just put that on the record, and I don't know if we can do that before the trial begins, before the evidence begins with the visit. It just might make it kind of weird doing that part.
So let me tell you, if you get your motion filed, we can hear it on May 2nd at 3 p.m. when we're scheduled for final hearing plea deadline. Or we can bring you in with your client at 1:30 on that date.
May 2nd.
Judge, if I may, I don't know if Mr. Huffman is done.
I think I could have it filed, Judge, by tomorrow, and I think the May 2nd would work, Judge.
Okay, Ms. Elizalde?
He had briefly mentioned something like this before. I'm not exactly sure why we waited so late in the game to file a motion for speedy, but I need appropriate time to respond that motion based on whatever he's saying. And on top of that, I'm starting, looks like a trial on April 28th, right before we even start on May 4th. I don't think realistically that I'm going to be ready to address a motion for speedy less than 10 days before the trial when I'm starting another one. And I am just trying to be very upfront with the court that I need to have time to respond, Judge.
And Judge, it's nothing complicated. It's a simple issue. I'm saying we would have had these texts had they pursued this case in a timely manner. And because of that, his speedy trial rights have been violated, and our remedy is a dismissal. So the issue is just very straightforward. And so, but I certainly understand Ms. Elizalde's response.
So were we not here on March 14th for a final hearing plea deadline? Did that not happen?
We've had a few, Judge. This is the second trial setting that I've had. So I know we've had a final before.
So the notation on the March 17 trial setting that was at defense counsel's request. I'm just throwing that out there. File what you need to, Ms. Elizalde.
No.
I understand that it's busy, but you're not the only person in your office. So if there needs to be, some work done, assuming it gets filed, it's not going to be set without adequate notice to the state to have a hearing. So Mr. Huffman, assuming we could accommodate you on May 2nd, you still have to get it filed.
I've got all my cases, Judge, and I just need to get my dates in order. It should have it filed by tomorrow, Your Honor.
But is it fair to say that we didn't hear about this, the court on March 14th? This was not something that was brought to the court's attention, was it?
And Judge, we've been trying a bunch of different ways to get these messages.
I know, but we were at final hearing plea deadline on March 14th, which means you were looking at a trial on March 17th. And it appears that defense counsel asked to postpone that trial setting. And now there's a motion to dismiss on speedy trial when you have your trial setting. I'm not really understanding.
The speedy trial violation happened years ago.
So why are we hearing about it 1 week before trial? Second setting trial. Well, I'm not hearing anything because there's no motion.
Yeah.
Oh. You have our dates, May 2nd, May 4th, and 5th. The only thing I need to know is I will confirm with you all if we have our visiting. I just think for our purposes of the process, it's better just to have one judge handle it. So I am going to confirm that we can get someone in addition to the 5th, also on the 4th, that same person to cover.
And then maybe the rest of the week, the
All
8th,
right.
9th, and 10th.
Oh, yeah, absolutely. The request is for the entirety of the week.
Okay.
Okay. Alrighty. We'll see you then. Anything else?
Yeah, at some point, Judge, I need to put the offer that was denied on the record.
Okay, so do you want to do that now or you want to wait till the final hearing?
I can do it now, Judge.
I'm sorry, what was it again, Ms.
I
Elisa?
can-
Oh, and there's something else I want to put on the record, Judge, but let me answer your question. The recommendation was essentially I'll dismiss the state jail possession charges and a plea to both cases as sexual assault. That'd be 10 deferred, Your Honor, with conditions, of course, but.
Okay, so the offer, if I'm understanding correctly, because there's 4 cases, right? Is 10 deferred on cause number 2021 0D01337 and 2022 0D00792. Is that right?
That's
10
correct.
deferred.
Mhm.
Okay, and that is with a dismissal on the other 2 cases, which is
Yes,
0253 and 0772.
That's correct, Your Honor. Mhm.
Mr. Alvarez, do you understand what the state's offer is? A dismissal of the 2 drug cases for pleas to 10 deferred on the 2 sexual assault cases. You understand that?
I've talked with Mr. Huffman about it. He said he was gonna come pay me a visit so we can discuss more about it.
Okay, so I'm gonna leave that right there.
Okay.
Right, whatever
Okay.
you're saying doesn't sound like a final answer. So we are coming back on May 2nd at 3 p.m. So, Mr. Huffman, I understand what you want to do. We can do it then once we have a little more clarity.
Understood, Your Honor.
Judge, just if it's okay with you, I also like to put it on the record. I understand we're coming back May 2nd. Given that we start May 4th, this probation recommendation is going to expire April 28th at 5 p.m. I
Okay,
will not offer it after that, Mr. Huffman.
so Mr. Alvarez, so you know, and I don't want to hear anything about what you talked with your attorney about. I understand you all are pending a conversation, but the state's offer of 10 deferred and the dismissal of the 2 drug cases is going to expire April 28th. Okay?
Okay, Ms.
I want to hear
Huffman.
that.
I'll be there. I'll be out there.
We'll talk,
I'll
okay?
be out there today.
Thank you.
Okay, so in the meantime, I'll get you a judge for the 4th. All right, anything else?
Sorry, Judge, I almost forgot. I had a conversation with Mr. Huffman about CPS records. It was notated in the supplement, so we both had noticed. Mr. Huffman, they have been requested, but Mr. Huffman has said that he wants to move forward without. And I think for Brady purposes, that should be on the record as well, Your Honor.
I was thinking you were talking about Voltaire.
No, CPS records listed on one of the cases, and I have a CPS person on one of my witness lists.
Yeah, if you can get me those records as soon as possible.
I can't, I've already requested them, but I don't have a way to get them to you as soon as possible.
Oh, okay.
I mean, I could try. I'm not gonna say I won't try, but I can't promise you that. I don't have control over that department.
Judge, I guess we can kind of cover that. We'll wait. We'll see what happens the next couple of days.
I suggest that we have Mr. Alvarez's final hearing plea deadline of May 2nd to be at 1:30 in person, transporting Mr. Alvarez over here. Okay?
Okay.
All right, so we'll bump that up, Myrna, from 3 p.m. to 1:30 in person. All right. Okay, thank you very much.
Thank you, Your Honor.
So is Barnaby the last one, or do we have something else?
No, Mr. Chavez is the last one, Chair.
Okay, let's get off of YouTube. Let me look.